Hello, my name is Susan Graham. I'm a certified elder law attorney in Boise, Idaho, and my business is named Senior Edge Legal. This video is to explain how an asset protection trust works for your children. We call them Heirloom Trust, Heritage Trust, Legacy Trust, Dynasty Trust, Inheritance Trust. I don't care what they're called. Doesn't matter what the name is, but the purpose of this trust is to protect any inheritance that is received by your children or your grandchildren. So I'm going to share a document with you. So let me share the screen with you. This is a trust for Sam Bailey, and his parents set it up for him. It's called an heirloom trust, but again, it could have many other names. In our office, we shifted some of the names when there's been a significant change in the assets or in the law that relates to these trusts, and it makes it a little easier for us to keep track, but it doesn't matter what the name is. So this is set up for Sam by his parents when they came in to set up their estate plan. I'm not going to go through every section of this because there really is no need, and that's not what you care about, although all of those sections are required. And the reason I have them in there is if there's ever an issue relating to the enforcement of this trust, those documents are necessary. But I'm going to hit the high points with you today. So the first thing is, of course, there's the name of the trust, and usually it's the child's name. And this has been set up by Donald and Sally Bailey for the benefit of Sam. So he's the primary beneficiary, and we refer to him as the beneficiary. Anybody after Sam, because this could go on for future generations, is called a principal beneficiary. The asset protection portion of this is in the second clause. It says the money that goes into that trust is designed to protect the trust assets and income from the claims of or interference from third parties, including but not limited to the spouses and creditors of all the beneficiaries. That's the really powerful section in that trust. It's an irrevocable trust, obviously. When we get to who's the trustee, during the lifetime of my clients, they're called the trust creators or the grantors. They could be their own trustees. Now, it's not often that I see any of my clients put money into the trust during their lifetime. The most common example when that occurs is they have a child or a grandchild who is having a tough time financially and they don't have their own home. The first one I did that I funded during the lifetime of a client was a gentleman whose daughter was in the middle of a really nasty divorce. She had 3 little kids and she didn't have a decent place to live. And he didn't want the house to be an issue of the divorce proceedings. So he purchased a home in a trust like this for the granddaughter, or excuse me, the daughter and her children, so they could live in it. He was the trustee. There was no way that was going to be on the table for any property divisions during the proceedings for the divorce. So sometimes they'd fund it during their lifetime, and it could be, if they do, they're the trustees of that trust, or anybody they designate in writing, or if they still funded it and they can't do it, and they didn't designate anybody else, it's going to be Sam himself, and then his brothers Lee, and Fred. When they're both gone, so they both die, then Sam is going to be his own trustee if they have not elected another trustee. And then Sam, during his lifetime, can elect anybody he wants to be the trustee when he's not able or when he's gone, when he dies. They can also resign and let this other new person be the trustee. But if he fails to nominate anybody and he can't serve as trustee due to incompetency or death, it's Lee and Fred. And then the principal beneficiaries, these are again the grandchildren or anybody who inherits after Sam, they can be their own trustees, normally at 30. There are studies that show young people don't really wake up and become truly engaged as adults until their late 20s. So we want to push it out till 30. If you don't say, it's at age 18. And the law says they're grown-ups at age 18, but we know that they really lack the skills to do that. There are two different assets that can go into this trust. And this is when the legal system gets a little confusing. There are qualified assets and non-qualified assets. Let me talk about qualified assets. Qualified assets are retirement benefits, okay? 401ks, IRAs, deferred comp, 403bs. Those are assets that have been acquired during your lifetime that you never paid income tax for. And when you're gone, the income comes out and has to be taxed to the recipient. So those are handled differently than non-qualified assets. Non-qualified assets are everything else, real property, money, brokerage accounts, that kind of thing. Article G talks about the disposition of the assets during the lifetime of Sam, and we have these four magic words that's for his health support, maintenance, and education. Of course, they can take into account any other income that Sam may have, but the trustee has broad discretion. But these four words are a brick wall between Sam and the rest of the world. That's part of the asset protection. When Sam dies, then it goes among his then living issue, meaning his children. And if he doesn't have any, then it goes to the descendants of the people who created this trust, of his parents. And then, of course, someday Sam's going to be dead and it's going to drop down to somebody else. Those people are called principal beneficiaries. Again, when those people die, it goes among their children. We call them living issue. That means natural adopted children, if any, and if there are none, against the living issue of the principal's nearest ancestor, who's a descendant of Sam, so it stays in Sam's family. And if there are none, then it goes to the descendants of the parents who set it up. We give, in most cases, we give the child and the future generations a power of appointment, meaning they can say where it's going to go when they die. If they don't, then it's going to be the default provisions that I just talked about up here. It'll be whatever the original creators of the trust said. But the distribution on the power of appointment, sometimes our clients limit it to it cannot be anybody other natural or adopted descendants, meaning it has to stay in the family. Sometimes people take that out totally, and there are tax reasons that the child cannot, or the beneficiary of this trust cannot do it in favor of themselves. We have a trust protector in this. It's a long section, but what it says is that there's a way that we can amend the trust without a court hearing if the law changes in the future. And the people that can change the law are the federal government, the state legislature, or judges could interpret the changes in the law. There are many other provisions in this as well, but these are the high points that most people are concerned about in these asset protection trusts for their children and their grandchildren for future generations. This can go on for future generations as long as anybody leaves the money in there. So it's wonderful that you consider doing that for your family, because you can protect that inheritance from all those sources outside that may attempt to grab it, and life is difficult. It protects them from divorces, from lawsuits, creditors, and bankruptcy. So it was really a foresight on your part and a very powerful a document that you created for their protection. They cannot protect it for themselves. So if you have further questions about that, please contact my office, Senior Edge Legal. You can go to our website or call and make an appointment. And I hope this has been of help to you. Again, thank you for the privilege of helping you. And I appreciate your taking the time to listen to this program.